Welcome, C3RF members, well-wishers from across Canada and beyond. Welcome to another session of In Hot. Today we'll be looking at one of the Liberal government of Canada's greatest overreaches in the form of the Order in Council that authorized the so-called gun grab of May 2020. Our wingman on this mission is going to be the incredible Christine Generoux, who took it upon herself to self-represent her own petition of judicial review to challenge the government and its travesty of due process and democracy. Now, Christine is simply a law-abiding citizen who became deeply involved in the firearms issue because she sees Canadian gun culture being destroyed at the expense of a key component of Canada's strength and freedom. She works as a technologist who chose to throw herself full force into a legal challenge of the government's gun control order in council that arbitrarily criminalized over 1,500 firearms in the spring of 2020. She felt compelled to do so to defend her legal property, equality, and cultural rights as a firearms owner. More than this, she believes that academic fraud and psychological operations are being used to trick average people into supporting gun control and erase Canada's heritage and history. She does not believe Canadian law and culture needs to be fundamentally changed. Now, before we get to Christine, this interview is sponsored by Madeleine Weld, a founding member of C3RF and a good friend and admirer of Christine. She is in awe of her cojones, as Madeleine says, as a self-rep with no legal background in taking on the federal government. Madeleine is not a gun owner, but understands that if a government can grab guns on false premises and pretexts, it is not likely to stop at guns. Bill by bill, rushed through Parliament with inadequate discussion, and by orders in council, Trudeau is crushing the freedoms and rights of Canadians. Christine is fighting back. We should all pitch in and help her. Those are the words of Madeleine Weld, our sponsor for this In Hot. Now over to Christine. And Christine, right off the top, I just have to ask, what got you going on this? This is an incredible journey, incredibly a great amount of work. What made you want to do this?
Well, I guess I'll lead in with people like you guys, people like Madeleine, people like you, Russ. Thank you guys for having me on the show. And I guess I was only minimally affected when I heard about the order in council. So I only have one gun on the list. At the time, I didn't even own an AR-15. It was just my small game rifle, which was previously non-restricted, which was affected. But as I told the judge when I recently went before her in an 8-day hearing, I'm not here over a $500 gun. I guess immediately when the order in council was released, I read the accompanying regulatory impact analysis statement. And that is supposed to be the basis of the opinion for the governor and council's decision. And the statement is rife with fraud, with contradictions. And I think that I just realized that this type of action, and not only regarding firearms, but the type of things that this government has been up to, are a serious threat to, my life, my security, and my liberty, and for that of future Canadians. So I felt like I had to do something, and I couldn't just stand idly by. And I, was reaching out to court challenge programs and funding and lawyers, and I was given profoundly bad legal advice. Pro Bono Ontario actually told me if I wanted to make a constitutional question regarding firearms, that I would need to get charged.
Oh, you
yeah, but I've
put
lived
yourself in jail.
Yeah, like I've lived in Canada for 35 years, and I knew that can't be true. If that's true, then yeah, it's too far gone, but it wasn't true. So I was trying to, reach out to lawyers, and I was told by several qualified counsel, we don't have property rights in Canada, we don't have firearm rights in Canada. And I'm sitting here going like, well, from what I know about the law, we do have property rights. They're contained in the Bill of Rights as well as in Section 8 of the Charter. Like, if you don't have property rights, then what is safe from search and seizure? Your property, from unreasonable seizure. So it turns out several lawyers actually do know that we have property rights in Canada. It's just many of them do not. And so I decided to just represent myself and kind of got thrown into this journey, launched a judicial review and a notice of constitutional question about the violation of my rights and that of other Canadians, and got started on an epic 3-year journey self-representing at the federal court.
Okay, when you talk about epic, I'm going to share a screen here for a sec, Christine, because I want to show our viewers just what's entailed here. And here is this is your notice of application for judicial review, and you can see that it's pages and pages and pages. A lot of work has gone into this piece of work, and then on top of that, you have your affidavit that you filed. This is a 41-page document. The last document was about 30 pages. This is 41 pages, and I want to draw your attention to this highlighted portion down here, because I think it really struck me as this is if this is what is going on, then we as Canadians are in real deep trouble. And you talk about in your affidavit that cultural genocide is the destruction of those structures and practices that allow the group to continue as a group. And through your affidavit and your testimony, you are actually saying that the government is going headlong after a whole identifiable group in Canada, their heritage, their history, their cultural rights, and as such, they are committing cultural genocide. Now, that term cultural genocide is not, it just doesn't show up here. It also shows up in other documents when it comes to Indigenous rights. So I noticed this is a very interesting link here, and I'm going to stop sharing. And I'd like you to talk about this whole idea of culture under attack. How did you approach this before the bench in both your? I know you had a sitting in front of the judge, in front of the bench for a motion to stay the OIC until it could be sorted out in court, and then you also had your day in court to fight the actual order in council just in this past April. How did you approach the bench with this idea of your culture being attacked and cultural genocide?
So in the very beginning, in my notice of constitutional question and in my application, when I was still, a real novice at legal writing, I just knew deep down inside that, my great grandfather owned guns, my grandfather owned, modern rifles of the day, right? And so did my dad at one point. And that is distinctly a part of what makes us Canadian. The gun culture has offered benefits to me on a personal level, as well as it offers endless benefits locally, provincially, nationally, internationally, everything ranging from, national security and preparedness to.
Could you say personally that gun culture actually turned your life around?
Yeah. So, I was a troubled youth, and I had, dropped out of school and everything like that. And it was only when I got back into, being in nature and hunting and sport shooting with my mentors and learning there's a professor who testified in the case because there were 6 applications, case managed together. And his name is Dr. Mauser, Gary Mauser, from Simon Fraser University. And he wrote an interesting article called Target Sports Teach Young People to Accept Personal Responsibility. And he likens it sort of to a martial art where, you're taught discipline, self-control, you take pride in your achievements. And it kind of helped give me a perspective and gave me a community to belong to, and helped, increase my self-esteem and putting me on the right path.
Yeah.
But I knew in the beginning that it was wrong to destroy someone's culture. And, the government of Canada has stated several times that, through the Multiculturalism Act, that it is the responsibility of the government of Canada to promote and enhance all cultures, and that it's the right of all cultures in Canada to mature and grow. So there's a caveat there that, barbaric cultural practices that hurt other people are not to be promoted, but harmless cultural practices are the responsibility of the government of Canada to promote and enhance. And in fact, sport shooting and possession of modern rifles of Canadians has been encouraged and promoted by the Canadian government since before Canada was Canada.
Yes.
For example, the Dominion of Canada Rifle Association, which was incorporated, by a special act of parliament with the explicit purpose of encouraging Canadians to own and shoot modern rifles. So I don't know why they're going back on that now, but I felt like I had to do something about it. And, the more I dug into the law and into the right to have my culture treated equally to other cultures, I did find that Canadians do actually have firearm rights. From everything from section 117.152 of the criminal code, part 3, which deals with our possession of firearms.
For hunting and fishing and.
Yeah.
Yeah.
And, to the Canadian Cultural Property Import and Export Act, which actually defines certain military firearms as Canadian cultural property. So I don't think I'm alone in thinking that,
Wow.
Yeah.
Your testimony is incredible here, because what you've done is actually you've gone across the board through acts of parliament, the Multicultural Act, to the criminal code. You have really dug deep into this subject area, and I have to give you full credit for doing so. That's just absolutely incredible.
Thanks.
I don't think I've seen since I become involved with charter rights and freedoms, I've seen a number of court cases. I've gone through and read many, and I can't say that I've seen many as detailed and as logical and coherent as yours, as you bring all these strands of the law into play. But one thing that really strikes me is you say that you felt in your heart that this is wrong. And that really strikes a chord with me, because you don't have to be a lawyer or a rocket scientist to know that something just doesn't feel right, this isn't right. And when I look at your case and the case the government has against guns, I'm really seeing kind of an oppressive mindset here. It's like it's almost trying to break away. Let's face it, the people who need guns, who want guns, it's part of their culture, are those people in rural Canada, in particular, or military folks like I used to be. But on the other hand, you have the urban folk, which are going to rely on the police, and they can be easily convinced that guns aren't needed. They have a policeman on call, say a couple of minutes away from the station. So it really seems like we're looking at an attack on an identifiable group here. We're breaking away. We're dividing Canadians on the basis of we're saying it's all about gun control and public safety, but really it's something deeper than that. I just feel that in my heart, that there's something deeper going on here. What would you say about that?
Yeah. So when I first started getting involved in firearm sports and hunting and stuff, I did some research, because I didn't want to be involved in a destructive activity. And there's a lot of rhetoric and propaganda surrounding gun violence in Canada. And when I first entered into this court case, I wondered if the government knew that what they were saying was fraudulent. And I found out along the way that, to myself, I've proven beyond a reasonable doubt that it is a violation of Criminal Code Section 380, what Bill Blair and other people have engaged in, because they're fully aware. They've been briefed, they know, and in fact, they actually are hiding and omitting data that exonerates people like me. So we have a principle of innocent until proven guilty here. And logical Canadians need to ask themselves, who is committing the crimes, which guns are they using, and where are the guns coming from? And throughout this journey, I've learned that, over 90% of crime guns, true crime guns that are actually used to commit violence in Canada, are smuggled through the US border. And I shouldn't be punished for that. And taking away my firearm isn't going to do anything to stop gangbangers from illegally shooting each other with illegal pistols in Toronto.
Right. Mm-hmm.
Yeah. And it's along the way, we actually got a really interesting answer from Trudeau's head counsel, Mr. McKinnon, at the first injunction, which you were referencing, to stay the regulation until it was decided in court. Now, we lost that, but I'm really glad I was able to cut my teeth on that motion, because we learned some valuable things, and it's a very hard test to pass. And the judge had ultimately ruled against us, saying we failed the second part of the test, which was that we couldn't prove irreparable harm. And, you know, she cited my so-called destruction of the gun culture. And she said something very important, which is that they haven't seized and destroyed the firearms yet. You're just not able to use them. The amnesty order is still in effect. So when we went back for a second injunction, when the amnesty order was running out, we knew that that would be the winner for the irreparable harm, that the property, which is invaluable, it's sentimental, is going to be seized and destroyed. And I don't think it's a coincidence that the government decided to pull out of that court hearing at the last minute and extend the amnesty by their own goodwill.
Oh,
Um,
okay. I
yeah,
was worried about that extension of the amnesty. I thought it was just because they couldn't find the folks to go out and actually search and seize. But you're saying that the judge actually in that injunction case back in January 2021, she actually did you a favor and say that yeah, there's no irreparable harm now, but just hang on because it looks like it's coming.
yeah,
Oh, that is extremely interesting.
yeah.
Okay.
It was a very interesting 3 years.
Well, let's talk about let's talk about the government's case. And in your documentation, you talk about you spend quite a bit of time pushing back against something called the regulatory impact analysis statement. Now, that I guess is the government's. That's the ace up their sleeve. They can plot this on the table and say there's public safety at issue here, and here's our impact analysis to prove it.
Yeah.
Could you talk to that statement? How did you find that
Sure.
to be as a document as
So
a case?
the main reason why I thought I actually could do something about this was the information contained in the RIAS is demonstrably false. And there's a reason why the government had all evidence that they used to come to this decision that the firearms are not reasonable for hunting and sport. They so I'll give the viewers a little bit of a side story here. Usually the respondent has 20 days to produce the documentary disclosure that they use to rely on. And the government begged an extension from the judge, and they got it for several months, claiming the magnitude of documents to be served and the COVID-19 pandemic. So when it came time for them to serve the documents, they actually blocked us all. They didn't produce a single page, and they said that it was all cabinet confidential under the Canada Evidence Act. Yeah. And that went on for about a year, and they would not produce a proper certificate from the clerk of the Privy Council. So we went to a disclosure motion on that, and we won. The applicants actually won, and the judge said to the government, I'm sorry, you can't rely on the protections of a confidentiality certificate if you don't bring a certificate. So you have 30 days to produce the documents for me. And 15 days later, the government committed what I read to be contempt of court by blocking her by producing a certificate. Now, her ruling was not to produce a certificate, it was to produce the documents alone. So they disobeyed a court order, a court-directed timeline, and they engaged in, a sort of frivolous and vexatious motion to block us from that disclosure. And I believe that it's likely that they did that because with that documentary disclosure, I probably could have proved fraud. But the RIAS is inherently fraudulent in that under the cost-benefit analysis in the RIAS, there's all these costs listed. Okay, there's 1.4 million hunters. There's 1.6 million sport shooters. They're going to be affected. Small businesses are going to be affected. They may need to go bankrupt, but there's no benefits listed at all. So they wouldn't even dare to say that it would actually have any measurable impact on reducing any sort of violence or crime in Canada. And when we got them on the hot seat and we cross-examined their witnesses and the head of the RCMP and everything, it came out that their argument is, we don't need to demonstrate that our law is logical, that it's economically viable, or that it will have any impact. We're the government, and we say it, that it's a good idea, and we don't have to prove that. And when we kept asking, this is what I was saying earlier at the injunction, when we kept asking the Crown, why have you left the terms in the Order in Council, and in the RIAS, military assault style rifle, variant, modified version? Because we found out after the fact that hundreds of firearms were being reclassified by the RCMP as prohibited in their firearms reference table, which carries serious legal consequences for Canadians without Canadians' knowledge. They were not gazetted. So We asked them, why didn't you define it? We have a letter from an ATIP here, from the Standing Joint Committee on the Scrutiny of Regulations, asking Jody Wilson-Raybould, you must define the terms variant and modified version. It has precipitated legal issues in the past. We know you have an internal definition you're using. Why don't you define it at law? If you don't, it's impermissibly vague.
Well, if they use it, if the term variant stays in place or modifications or whatever, then that just opens the door for anything down the road to be classified as a variant, and basically all the guns are gone.
It's honestly, it's illegal. That's why I told the judge, very simple terms in the criminal code are defined: cattle, banknote, nighttime. It has to be defined. And the Standing Joint Committee of Scrutiny of Regulations never got an answer, but we did. And Trudeau's head counsel stuttered and stammered when the judge asked him why they wouldn't define it. And he said, but, Your Honor, if we define it, then people and manufacturers can just get around it by, buying and selling firearms that aren't prohibited.
So the whole idea is to not to have a situation where manufacturers can make a product and people can buy it for their own enjoyment. But the other thing that sticks in my mind, go back a couple of minutes. You said reasonable. You said the government didn't have to. It didn't show in the cost benefit analysis. It didn't show the benefit side of it. So how could it possibly prove that its order in council or any other law that they come up with in this regard is reasonable? And to be reasonable, you have to look at both sides of the argument. And when you talk about reasonable, you're actually talking about charter rights, because we're covered, we're protected from government overreach by a charter that says that the government has to legislate and deal with us in a reasonable fashion. They can limit our freedoms, but it has to be reasonable, has to be demonstrably justified. So we have a government that's running, that's using the order in council as basically an American-style executive order to short circuit parliamentary debate, to short circuit representative democracy, and basically rule by fiat. And they don't even have to be reasonable when they're dragged into court to prove that what they're doing is for our benefit.
Well,
Absolutely.
And that was their only argument, was, we're the government, what we say goes. But myself, as well as, the qualified lawyers on our side, said, you're playing around with definitions there, and they do tend to do that. And no, you are held to see, the normal standard of review on a judicial review is reasonability, like reasonableness, and the normal standard of review on a constitutional question is correctness. So facts and law matter. And they were doing this word salad, saying, well, the opinion of the governor and council on what's reasonable for use in hunting and sport doesn't need to be reasonable necessarily. And we're saying, yes, by the case law, it actually does.
Yes. Mm-hmm.
And they just love to play around with definitions like that. They did the same thing with quietly changing the definition of crime gun in 2014, certain departments to include nonviolent administrative offenses, so that Bill Blair could go on TV and say half of crime guns are domestically sourced, insinuating that it's from licensees, when in reality that includes nonviolent administrative offenses like forgetting to renew your license.
Yeah, I think I saw in one of your presentations, I forget where it was, but it said that the government had actually classified firearms paper problems. You didn't fill in the form right, or you didn't do the paper right. Your submission was an error. They're counting that as a gun crime.
Yep.
Any weapon associated with that kind of a problem was a gun crime problem, which is absolutely fraudulent. I would suggest that
it is, when it's used to take away your valuable rights and to claim that it's related to violence. It is fraudulent. Yeah.
Oh my God. Now I'm noticing, I'm going to make a bit of a link here with your case. The government rule by fiat, the order in council, and public safety. They're saying that they're fully justified in doing what they did, rule by fiat, because they have public safety foremost in their mind. And I'm making a linkage here with a recent virus pandemic, where the government came out and said, well, it's all about public safety. We have to be safe. So boom, you can't travel if you're not vaccinated. You can't do this, you can't do that. You got to wear a mask. You can't shop in that store. You have to. Oh, you can't go to that church. You can't worship, but you can go to the LCBO in Ontario. We have our liquor control board. You can go there, or you can go to a strip show. Yeah. So they come up with all these arbitrary things in the name of public safety. And there have been some court rulings on the. This has been taken forward by some folks to the courts, and the courts have ruled on it. And they said, no, we have to rule with the government because we have to afford the government what they call a margin of appreciation.
Mm-hmm. Deference, yeah.
Now, yeah, deference to the government because we're not the experts. The government's the expert, but we actually are finding out many times over in the case of the virus that the government wasn't the expert. They were wrong almost in everything. So, do you think this margin of appreciation is going to play into the decision that's going to come out of your latest court proceeding?
Oh, it certainly will, and it has. But we also have a few secret weapons up on our side. And I mean, I remember in the beginning, people saying, you can't beat the government. They have, unlimited funds and this and that and dirty tricks. And I said, yeah, but I have the truth. And I mean, it's funny because out of, 100,000 pages of documentary evidence that the judge has to look at, and that's, my record was almost 9,000 pages. And that is largely due to the obfuscation and of the Crown's witnesses. They would not answer questions. There was thousands and thousands of pages of cross exams. Their strategy is to lawfare, tire you out financially at $5 a page on regular turnaround. Oh. But it's funny because we've brought stacks of Canadian foremost experts, criminologists, Statistics Canada data, government memos, SECU presentations. And they brought primarily foreign propagandists from Australia and from America, sensationally talking about mass shootings. But I feel that what is going to win this for the applicants is the words of the government. And I mean, I believe they put their foot in their mouth because when you lie and you're not telling the truth, you have to then go back and cover your lies and remember what you said. And in the regulatory impact analysis statement, the government said that our opinion that they're not reasonable for use in hunting and sport, even though you may have been using them, millions of people use them for over a century in Canada for that, is based on the fact that they're too dangerous for an occasional use in murder. Now, that's when they put their foot in their mouth, because the opinion is to be based on what's reasonable for use in hunting and sport alone. And, the government of Alberta intervened on our behalf, the Attorney General of Alberta, and came to speak. And they had a beautifully short, succinct argument. They could say what took me 5-6 hours to say in 20 minutes. And they said, words matter. You have to give this restriction meaning. What is the restriction there for, if not to protect our firearms, which are reasonable for use in hunting and sport? And they said, if you don't, then we'll have a constitutional issue because that infringes on Alberta's input that we had in these legislations. Yeah. So the restriction is there for a reason, and it's not so that reasonable firearms can be prohibited under this mechanism. Yeah. And I think that Trudeau knows that, which is why he shortly after, during the court case, he was trying to ram through Bill C-21. It's a form of admission of guilt. And it's, I guess, in the legal terms, it's what they call estoppel, because throughout the court case with us, he said, we don't need to define. It is not arbitrary that we've banned some center fire semi-automatic rifles and not other identical ones. It is not arbitrary. It is not vague. It's fine. But meanwhile, in Bill C-21, he's trying to correct all those issues. So that's sort of an admission of guilt.
So he's trying to cover his tracks by going back and extending seizures or amnesty or modifying, as they did recently, the rule for semi-automatics and magazines and that type of thing. It really seems, well, you got the truth on your side. And, that tells me that the government's in for a lot of trouble here, because I think they're walking into a buzzsaw. And we can already see that with folks like yourself standing up and fighting back, Christine, at your own expense and time. But as you mentioned, we're also seeing other provinces, Alberta, start to swing in behind your case. I think there's a couple of provinces on the East Coast that are looking at this very, very seriously. So I think the government is walking into a constitutional crisis here.
Absolutely.
And maybe it's overdue because with what the government's been doing over the course of the virus pandemic has been incredibly draconian, and it's not Canadian. It's just not Canadian. But is there anything that you'd like to finish off with, Christine? I know that I don't want to keep you all day here. I could, but I don't want to keep you all day. Any last parting remarks that you have for the audience?
Well, in 2020, when this was announced, during a pandemic, when Parliament was prorogued, and I got a little bit of a wind in the newspaper that this order in council was abused in order to cram this gun ban through. And we know that disarmament is a major agenda of the globalists, is a major agenda of hostile foreign entities who want to disarm us for their own gain. And that kind of scared me. And later on, and it was supposed to be just a rumor, but later on it came out, there was an affidavit sworn in the case by a woman named Natasha Beggs, who had an email exchange the day before the OIC was gazetted on April 30th, 2020. And she had an email exchange with an ex-disgraced Liberal MP named Marwan Tabera. Yes. And I find it very funny how, he was a big purporter of gun control. I'm a risk to become a mass shooter, and I straw purchase, so you need to disarm me. But, you're the one who's been convicted and brought up on charges for stalking, and assaulting your ex-wife. So, but he emailed to this lady and he said, we couldn't get the necessary consent to pass this through Parliament. Therefore, the instrument choice of an order in council was used. And I mean, I would say abused.
Yes.
And this nonsense with Bill C-21, now it's in the Senate. And it is their third attempt to bring this bill. And they keep removing firearms that average Canadians from the Yukon to, Manitoba to Nova Scotia are saying no. These are our essential hunting and sport shooting firearms. And if you take them away, you will destroy our ability to meaningfully participate. And I think that the only reason why we haven't been disarmed already is because 2.6 million Canadians have their PAL. They're standing up in that way to the government to say, no, this is an issue. We care about this, and we're willing to jump through all the hoops. You're not taking this away from us. So I really think that, peaceable and law-abiding civilians really need to get involved in this now and fight for, our rights to have firearms.
Okay. What I'm seeing here, what I'm imagining in my mind is we're actually having a coalition of Canadians come together. We've got the folks who belong to the gun culture, who want to preserve their gun culture, and we also have people like the Freedom Convoy 2022 truckers standing up against this overreach. In one case, it's to defeat gun control. In the other case, it's to defeat draconian vaccine mandates. But it's all coming under the same umbrella. I would think anyway that
they're all interrelated.
Canadians are starting to stand up, is what they're doing.
Yeah, they're all interrelated topics, and it all comes with erasing your identity, your values, your heritage. We're going to be this beautiful post-national state that.
Oh, isn't that funny that you should mention that? Because when Trudeau first came into power, he was quoted as saying that Canada is a country of no core values, basically no culture. And you were begging to disagree with that there is culture.
Yep, I would beg to differ.
Long established heritage, history, and culture. And you're going to fight back and preserve it.
Yeah, do my best.
Well, I have to thank you on behalf of all C3RF members for being with us today, and basically for all of Canada, because we need valiant warriors like yourself, Christine, to stand up. Hopefully, you'll serve as an example for Canadians across the land to stand up, fight back. Before I go, I noticed in your injunction case of 2021, I think you're liable for costs for the other side. Okay. What I'd like to do is, before we go, I want to do a screen share here. Is this still active, this GoFundMe?
It is, yeah.
Okay, so ladies and gentlemen, take a look at Christine Generoux's GoFundMe and give a consideration to helping her fight this fight.
Yeah, the donors and the culture have been really generous and supportive of me thus far, and it's one of the only reasons I've been able to continue with this fight. So,
of course, I mean, without the money, it's going to be impossible. So with that, thanks again. Thanks once again, Christine. It's been a pleasure to have you, and hopefully we'll talk soon.
thank you so much, Russ.
Okay.
Bye.